article about Iraqi security forces. Also, Congressman Steve LaTourette on the future of Amtrak and the recent firing of President David Gunn. And Republican Michael Castle of Delaware talks about what moderates in his party want in the House budget bill. The House meets at 10:30 for morning hour and noon for legislative business with work on suspension bills. On C-SPAN 2, the Senate comes into session at 9:45 a.m. to continue work on the defense authorization bill. At 10 on C-SPAN 3, the Senate Finance Committee holds a confirmation hearing for Ben Bernanke, who's nominated to replace Alan Greenspan as Federal Reserve Board chairman. History programming at 10 p.m. focuses on the last three British prime ministers, Margaret Thatcher, John Major, and Tony Blair. A hearing now on TV cameras in the courts. The Senate Judiciary Committee hears from judges, attorneys, and television executives about proposed legislation on the issue. This is a little over 2 hours.
Good morning, ladies and gentlemen. The Judiciary Committee will now proceed on our hearing on cameras in the courtroom. The ranking member will be joining us very shortly. This is a subject of enormous importance to the American people on the basics of understanding how the government functions. Senator Grassley, who is our lead witness today, has had legislation pending on cameras in the courtrooms of the circuit courts and the district courts, and I have had legislation pending since 2000 for some 5 years to open up the Supreme Court of the United States to cameras. The Supreme Court, as our system of government has evolved, is deciding the cutting-edge questions of our day, decisions on who will live and who will die, what is the power of the president, what is the relative power of the Congress, whether marijuana may be used for medicinal purposes, where the balance will lie on a woman's right to choose, what DNA evidence may be used to exonerate the innocents, and the whole range of cutting-edge questions have been left really to the Supreme Court of the United States. And in the year 2000, the court in effect decided who would be the president of the United States. There was the largest array of television trucks that I have ever seen, and I've seen assemblages of television trucks in front of the Supreme Court building when that case was decided. And it was, I thought, most unfortunate that the cameras were not allowed inside so that the American people and the people of the world could see precisely what was going on. At that time, Senator Biden and I had written to the Chief Justice urging that the case be open to television. Chief Justice declined. They did release an oral transcript shortly after the hearings ended, and that was illuminating, but far from what would have been apparent had cameras been in the courtroom. The House of Representatives and the Senate have been televised now for decades, and I think at the outset there might have been some grandstanding, so to speak, but it has been an enormously useful tool for public understanding as to how the Congress works. And the hearings of the House and Senate have long been televised, and the comments that I hear most frequently about television relate either to the NFL, the World Series, or C-SPAN, and late night viewing is practically captured by C-SPAN. It is my thinking that the Congress has the authority to legislate on cameras in the courtroom for the Supreme Court. The Congress makes the determination as to how many justices there are on the court. The Congress makes the determination of what is a quorum for the court. The Congress makes the determination for when the court will begin its session on the first Monday in October. The Congress has imposed time limits for the Supreme Court, and by analogy to those lines, I think it is fair for the Congress to legislate in this field. Obviously, if the Supreme Court decides as a matter of separation of powers that it is not a congressional prerogative, we will not petition for a rehearing. That will be the judicial decision, which we respect since Marbury versus Madison. We have a distinguished array of witnesses today. Our lead witness is Senator Charles Grassley, senior senator from Iowa, came to the United States Senate in 1980, a banner year for Republicans. Some 16 Republicans were elected that year, and two of them were Charles Grassley and Arlen Specter. And the only two survivors are the two of us. Senator Grassley was once analogized. I want to be a little more liberal with the time since no other senators on the panel. I usually stop promptly with the red light. Senator Grassley was once analogized or compared to President Harry Truman as being very plain-spoken, but the expression was horse sense. And with Senator Grassley's background as a farmer, he took it as a compliment, and it was intended as a compliment, and I can say that with some certainty because it was my statement about Senator Grassley. Welcome, Senator Grassley. You're a distinguished member of this committee. You're a distinguished member of the Senate, and we look forward to your testimony.
Well, thank you very much for giving us an opportunity to speak about openness in our courts. And as you know, I've long championed this, and most recently with Senator Schumer, going way back to the 106th Congress when we first introduced this Sunshine Bill. And over the years, it's enjoyed bipartisan co-sponsorship. And we have had the opportunity of getting our bill out of this committee 3 times since that 106th Congress. Just a couple of months ago, the new Chief Justice testified before our committee about this issue when I and several members asked, and he seemed to have a great deal of open-mindedness on this subject. Today's hearing, I hope, will help him with facts needed to make decisions to open the Supreme Court as well as other federal courts to cameras. As you know, the House Judiciary Committee just passed out by a vote of 20 to 12 a House companion that was introduced by Congressman Chabot. The Grassley-Schumer bill will give federal judges the discretion to allow for photographing, electronic recording, broadcasting, and televising federal courts. The bill will help the public become better acquainted about the judicial process, produce, I think, a healthier judiciary, increase public scrutiny, brings greater accountability, and I think help judges to do a better job. The sun needs to shine in on the federal courts. In this room, we often talk about the intentions of founding fathers. I think allowing cameras in the federal courtroom is absolutely consistent with their intent that trials be held in front of as many people as choose to attend. I believe the First Amendment requires court proceedings to open to the public and, by extension, news media. As the Supreme Court articulated in 1947, Craig Harney, quote, "A trial is a public event." Another quote, "What transpires in the courtroom is public property." And the Supreme Court stated in 80 ruling, Richmond newspaper, people in open society do not demand infallibility from their institutions, but it's difficult for them to accept what they are prohibited from observing. Beyond the First Amendment implications, enactment of our bill would assist in the implementation of Sixth Amendment guarantee of public trials in criminal cases. In 1948, Oliver opinion quotes, Whatever other benefits the guarantee to an accused that his trial be conducted in public may confer upon society, the guarantee has always been recognized as a safeguard against any attempt to employ our courts as instruments of prosecution. The court stressed that, quote, the knowledge that every criminal trial is subject to contemporaneous review in the form of public opinion is an effective restraint on possible abuse of judicial power, end of quote. Louis Brandeis captured it better by saying sunshine is the best disinfectant. During this morning's hearing, we're going to hear from opponents. Much of their opposition is based on speculation and false assumptions. That criticism ignores the findings of at least 15 state studies and a large federal pilot program. The widespread use of cameras in state court proceedings show that still and video cameras can be used without any problems and that procedural discipline is observed. All 50 states allow for some modern audiovisual coverage of court proceedings. My own state of Iowa has done this for almost 30 years. There are many benefits and no substantial detriment to allowing greater public access to the inner workings of our courts. 15 states conducted studies aimed specifically at the educational benefits derived from cameras. They all determined that camera coverage contributed to greater public understanding of the judicial process. Further, at the federal level, the Federal Judicial Center conducted a pilot program in '94 which studies the effects of cameras in selected courts. That study found, quote, small or no effect of camera presence on participants in proceedings, courtroom decorum, and administration of justice, end of quote. However, in order to be certain of the safety and integrity of our judicial system, we have included a 3-year sunset. It is also important to note that the bill simply gives judges the discretion to use them in the courtroom. If it does not require the judges to do that. The bill also protects anonymity of non-party witnesses by giving them the right of their voices and images to be obscured. So this bill doesn't require, but allows judges to exercise their discretion to permit cameras in the appropriate. I think it guarantees safety for our witnesses and doesn't compromise that safety. So I hope we can pass it out of our committee once again, Mr. Chairman.
Thank you very much, Senator Grassley. We've been joined by Senator Sessions. Senator Sessions, would you care to make an opening statement?
No, Mr. Chairman. Just would say, chairing the Administration and Court Subcommittee and giving a lot of thought to this, I think we need to go carefully here, and I'm looking forward to the panel and discussing the issues.
Thank you very much, Senator Sessions. We now turn to another distinguished member of this committee, Senator Charles Schumer from the state of New York. Senator Schumer went directly from the Harvard Law School to the New York Assembly and then directly to the U.S. House of Representatives, and then in 1998 was elected to the United States Senate, and much to the dismay of his parents, as he has told the story. Right from law school to public service without any intervening big bucks. But Chuck Schumer is dedicated to public service in a big way. He has run into big bucks, however, not for himself personally, but in his prodigious fundraising capabilities. He can give tips to all of his 534 colleagues on television access. May the record show he's nodding in the affirmative. And we find him to be very, very active and a great contributor to this committee, and we welcome him here this morning for his testimony.
Well, thank you, Mr. Chairman. I appreciate your kind, I guess, kind introduction, and am honored to serve with you. I would note two quick things. I came to the Congress in 1980. You mentioned that was the, I think, 16 senators, new senators. I was one of 7 freshman congressmen from New York, a Democratic blue state, 6 Republicans and myself. And I think I'm the, let's see, Yeah, I think I'm the only one who's still there, too, just as you and Senator Grassley are. And the other thing that links Senator Grassley on this bill, we are the only two Charles E's in the Senate who are nicknamed Chuck. Anyway, thank you, Mr. Chairman. I want to thank you and Senator Leahy for scheduling this hearing. It's an important hearing about people's ability to participate in this great democracy. Public interest in our court system is higher than ever. And that's a good thing, because our democracy is stronger when participation is strong. No branch of our government has remained a greater mystery to average people than our federal courts. And that's a shame, because of the decisions of our courts and the judges who sit on them, judges who get a lifetime appointment, have tremendous consequences for everyday lives. An example. No case has had a profound effect on the lives of Americans as much as when the Supreme Court helped decide the presidential election 5 years ago in Bush v. Gore. We all remember that case. No matter what side you were on, you were riveted every step of the way. There was lots of concern then. There still is a lot of talk about that case now. But the court realized that, and this was what's so interesting. With Bush v. Gore, the court also made history in one other way. For the first time in its history, the court released an audio tape immediately after the proceedings. The tape was broadcast all over television and all over the radio. Millions of Americans listened intently just to get a feel for what was going on inside the hallowed halls of the Supreme Court. And ask any one of them if they would have liked to have the opportunity to watch the proceedings. The answer would have been an overwhelming yes. Well, if the court did that in Bush v. Gore, a case very important, particularly to people who care about politics, when they get a case on disability, there are people who care about that, maybe more so. When they get a case on the environment, there are people who care about that. When they get a case on business law, there are business leaders who care about that. And I think the same standard ought to hold. And that's why I'm proud to co-sponsor a bill with my colleague, Senator Grassley. As he mentioned, we've worked on this a long time together, and we've had some success in moving it out of this committee. I think this is the year to make this law. The reason of the bill is simple. It's openness. Courts are an important part of our government. The more people know how government works, the better. But the federal government, as has been mentioned, lags far behind the states. I want to give another example in my own home state of how openness worked. We've allowed televised trials for decades. It's been a great success. Even in the cases, the critics say, oh, the cases of strong passion will become circuses and everything else. Well, there was no case New Yorkers felt more strongly about than the case of Amadou Diallo. 4 police officers eventually acquitted, but they were accused of shooting Diallo, a Nigerian immigrant, in cold blood. And because the case got such wide concern, the venue was moved from the Bronx to Albany. But the judge wisely permitted live TV coverage. It allowed anyone who was interested to watch the entire trial, whether they lived in the Bronx, the neighborhood where it occurred, or elsewhere. The camera was not disruptive. The lawyers acted professionally. The rights of witnesses were not curtailed. Witnesses and jurors were not in the room. And so it didn't diminish the dignity of the court, but at the same time, when the public, many people, particularly in the African-American community, were very upset about this, and when they were able to watch the proceedings, most people agreed, whether they agreed with the outcome or not, that the jury decided that it was a fair trial. That wouldn't have happened if we didn't have cameras in the courtroom. For people to just read the newspaper accounts doesn't give the same. So this works. Allowing our cameras into our courtroom will help demystify the courts. Let the public evaluate how well the system works. Only then will the public really be able to decide, based on facts and real knowledge, what changes need to be made. And finally, as Senator Grassley mentioned, there are instances where cameras are not appropriate, and this bill takes care of that by granting discretion to the judge. If for any reason we don't really tie the judge's hands on this, even though, as you note, Mr. Chairman, we probably could, although the court would have to rule on that, a la Marbury versus Madison, but if the judge thinks that televising a trial would be harmful, maybe he thinks it's unfair to the defendant, maybe there are privacy concerns, the judge could ban them. It also allows witnesses to request, as was mentioned, that their voices and images be obscured. So the risk here isn't turning courtrooms into a circus or unduly invading someone's privacy. The risk is the danger we pose to our society and our democracy when we close off our institutions to the people they're supposed to serve. Thank you, Mr. Chairman.
Thank you very much, Senator Schumer. Turn now to our distinguished ranking member, Senator Leahy.
Well, Mr. Chairman, I just wouldn't wait for Senator Grassley. Oh, you're done. Okay, well then I will speak. I'm sorry I can't.
You think we call on Schumer before Grassley?
I'm sorry. I'm sorry you missed it too.
I know these two are not just two pretty faces. They're here for substance, and I was going. No, I didn't realize Senator Grassley had already spoken, or I would have been. I was going to wait for him, but I'm glad to see this hearing. I'm the son of a printer. My parents had not only a printing business, but for a while ran a small newspaper. So I come by my affection for the First Amendment very honestly and directly. My father instilled in me the sense that the freedom of speech, First Amendment's foundation of this democracy. But it also ensures that we'll have access to our government. When I was a young man, actually when I was a young prosecutor in Vermont, Vermont even then had this culture of open government. We could talk to our elected officials, meet with them on a regular basis. You can have balances for security, but there has to be this transparency. We have to know what's going on. A democracy works best when there's sunshine in government. I think right now there's this dramatic shift towards secrecy in the government, and that's bad. It hurts the whole country. So we have to expand access to government for all Americans. I've tried to make all three branches of our government more transparent and accessible. Congress and its committees, except for a rare secret session, we're open. We're carried live on cable television, C-SPAN, radio. Members in the committees use the internet and the web to let you know what's going on. The executive branch is subject to the FOIA, Freedom of Information Act. So we then have the third branch. Now, most judicial proceedings are open to those who can travel to the courthouse and wait in line, and they can see what's going on. But emerging technology could invite the rest of the country into that same courtroom. You wouldn't have to travel there. Everybody in the country, whether I'm sitting in my little farmhouse in Middlesex or somebody is in their office, anybody could be in that courtroom with technology. All 50 states have allowed some form of audio or video coverage of court proceedings, but the federal courts lag behind. I've co-sponsored several bills to address this, including 2 bills currently pending. The one we've talked about, the Courtroom Act of 2005, and the Televised Supreme Court Proceedings Act with Senator Specter. You know, the First Amendment is one of those magnificent bequests to all Americans, and we have to protect it for succeeding generations. It's a fragile gift. It needs nurturing. It needs protection by every new generation. Let's use the technology available to this generation to give even greater guarantees to that amendment and the free and open government it facilitates. It's time to let some sunshine into our federal courts. So the federal courts are the bulwark for the protection of individual rights and liberties. The Supreme Court is often the final arbiter of constitutional questions, having a profound effect on all Americans. Why not allow the public greater access to the public proceedings of the federal courts? That's going to allow Americans to evaluate for themselves, ourselves, all of us, the quality of justice in this country. They're there for all 280 million Americans. Let all 280 million Americans know what's going on. It can deepen the understanding of the works in the courts, but it could also deepen our understanding that it's our rights, every one of it, our rights. They're there being protected. It's a fascinating subject, and it is time for this. I remember when I first came to the Senate, we did not have television. We brought in radio during the Panama Canal debates. People tuned in throughout the country. They got involved, and we had television. That was an interesting experiment. Sometimes it's been good, sometimes it's been bad. Sometimes it's been posturing, sometimes it's been riveting matters. But the American people could see what they had a right to see if they traveled to Washington, stood in line, and went in there. Well, I can see what goes on in my federal courts. If I travel to the court, stand in line, go in there. I want to be able to see from wherever I am. Thank you, Mr. Chairman.
Thank you very much, Senator Schumer. Just a question or two. Thank you, Senator Leahy. Just a question or two, Senator Schumer. Do you think that presence of the cameras in the courtroom, in the Senate, rather, has any significant effect on promoting grandstanding or hot dogging among the senators?
I think that the overall benefit of having C-SPAN with millions of Americans watching, there are now call-in shows where people respond to what's going on, has been extremely salutary for our democracy.
And that's the next question. With respect to what do you hear from your constituents about viewing C-SPAN and watching the Senate proceedings, and how much enlightenment does it give them as to what we're doing?
Mr. Chairman, I am amazed at how many people actually tune into C-SPAN and how often you hear it. I mean, maybe the average person doesn't, but a large number of people do. And again, it's demystified the Congress. It's different having an intermediary tell you what happened through their eyes rather than seeing it through your own eyes. And what C-SPAN does, and camera in the courtroom does, is let anyone who wants to, as Patrick Leahy said, view it themselves.
And how about the C-SPAN coverage of hearings? How many of your friendly insomniacs tell you that they saw you at 3 a.m. or at some other ungodly hour?
Yeah. No, I agree. You hear about it all the time for hearings and for everything else. It's, I think it's, have there been occasional times, I guess, when people might regret having C-SPAN in the Senate chamber in the hearings? Once in a blue moon, very, very rarely. And the benefit is every day, every minute.
Senator Leahy.
You know, what you're talking about, the chairman talked about the insomniacs at 3 o'clock, but they're making that choice.
You got it.
To watch it. And I know a number of emails and letters I get, even from a little state like Vermont, a number of people who watch. But it doesn't also, though, come down again, if you have an interest in what's going on in that court, you can watch it.
Exactly.
You've been there for Supreme Court arguments, as I have. I'm a member of the Supreme Court bar. Senator Specter's argued cases there. We know that some of the cases can be awfully arcane. Fine. But the case that we may find arcane may have a very, very direct relationship to somebody else's rights or interests. Why not be able to watch it?
Right.
And again, I come back to the point, if you can spend the money to travel to where the court is and stand in line, you might get in and watch it. It's an open courthouse. Why shouldn't it be open to everybody?
Exactly.
Electronic age. So I was chairman, I thank you for having these hearings, and I agree with Senator Schumer. I agree with you and Senator Grassley.
Senator Sessions.
I thank Chairman and Senator Schumer of your remarks. I think they are worthy of serious consideration. We serve on the court subcommittee together. During that Democratic spring, you chaired the committee, and then now I chair that subcommittee. I believe the courts are somewhat different than Congress. I believe the primary charge of a court is to provide justice in the case before it, not to entertain and not to create circumstances that might undermine that. So as a person who spent a lot of time in the courtroom, who dealt with witnesses, talked to them, held their hands, seen them cry before going in there. Many times I comforted them to say, well, probably all that's going to be there is some of the family and a few other people, and don't worry about that. And that was some comfort to them. Judges and polls show that witnesses would be affected by the fact that what they may say about most intimate, personal, emotional issues, family disputes, or love affairs, and those kind of things, personal admissions of errors and wrongdoings, or maybe even criminality that they participate in, that they have to testify to. I think it is a basis for concern, particularly in the trial court, that the ability to get truth and witnesses to cooperate and testify accurately would be undermined. That's what the judges believe, and that's where I am, particularly on the trial court. I'm not unhappy with the process that's established now for the circuit court, and believe the proposed legislation that allows the presiding judge to make the call rather than the judicial council would be less satisfactory. That would be an aberrational process that would be not as justified, in my view, as a uniform council policy. The Supreme Court obviously began to loosen up some. They've allowed their arguments to be taped and produced, but they likewise have given this consideration quite a number of times and have concluded that they do not wish that their lawyers in the process to be a television show, and that they would prefer it be focused on the law of the case. The judges ask awfully technical legal questions. That's what the American rule of law often is standing and procedural matters and statutes of limitations and those kind of things. There could be a tendency, I think, even for judges to go more away from those issues and to the more dramatic issue that may have attracted the attention of the public. So I think the court is wise to consider this. I think someone asked new Chief Justice Roberts what his views were on this subject, and I'm not sure what he said, but he obviously has left it open, and the court has the ability to do that. So, Mr. Chairman, I know that there's a strong push for this. I know a lot of the TV networks would like to see this occur. I respect what they do and respect the work that they perform, but my feeling at this point is we should be very careful about this, and particularly by personal experience with trial courts, federal district courts, we should not go forward to impose or allow cameras in the courtroom. So,
Senator Sessions, when you say you weren't quite sure what Chief Justice Roberts said in response to the question.
I think you asked it, maybe.
Oh, I asked him.
What did he say, Mr. Chairman?
Well, first I want to comment on your comment where you said you weren't sure about what he said. Many of us weren't sure about what he said in answers to many questions. His response to that question was that he had an open mind. That was before he was confirmed, however. My view has been that the nominees answer about as many questions as they think they have to, and they're as compliant as they can be, consistent with their consciences and what they may do later. But
you're a wise and experienced chairman, Mr. Chairman.
But we will revisit that. There are more people on television. I walked into my office this morning and saw Justice Breyer on television. You see Justice Scalia on television. It's coming.
Mr. Chairman, I would say this, that in the evaluation of it, I think the least detrimental would be the Supreme Court. The next detrimental consequences perhaps would be the courts of appeal, and the most detrimental from my perspective would be the trial courts. We'll just see how it goes.
Okay, well, thank you for that.
I look forward to the hearing.
Thank you for that, Senator Sessions. I'm putting you down on my tally sheet as leaning. We're going to now turn to judicial panel. Thank you very much for joining us, Senator Schumer, and you're welcome to stay. Our first witness is Judge Diarmuid O'Scanlan, Ninth Circuit judge, having been confirmed in 1986, has had a distinguished record in public service in a variety of positions, was on the advisory panel for the U.S. Secretary of Energy, He'd been the director of the Oregon Department of Environmental Quality, Deputy State Attorney General for Oregon, served in the Judge Advocate General's, a bachelor's from St. John's and a law degree from Harvard, JD, and an LLM from the University of Virginia. Thank you for joining us, Judge O'Scanlan, and we look forward to your testimony.
Thank you very much, Mr. Chairman and members of the committee. My name is Dermot O'Scanlan, United States Circuit Judge for the Ninth Circuit with chambers in Portland, Oregon. And I thank you for inviting me to share my personal experience with televised proceedings of the U.S. Court of Appeals for the Ninth Circuit. Our court is one of two courts of appeals involved in a pilot program under which audio equipment, still cameras, or video cameras can be admitted to the courtroom upon request and with approval from the panel hearing the case. Since 1991 until last week, we have logged 205 requests to allow media into oral arguments. Of these requests, the panels granted 133. But to give some perspective, the Ninth Circuit has heard oral arguments in approximately 24,000 cases since 1991, meaning that media requests for videotaping or live television have been requested in less than 1% of the total cases receiving oral argument. To gain access to a Ninth Circuit courtroom, a member of the media with cameras need only fill out a simple form requesting very basic information. The clerk of the court then transmits the request to the panel, which can grant or deny the request by majority vote of the judges assigned to that case. The Ninth Circuit requires media representatives to obey modest guidelines, which request proper attire, ban the use of flash photography or other potentially distracting filming, prohibit the broadcast of any audio conversations between clients and attorneys, and limit the total number of cameras that can be present for any single oral argument. The committee might also be interested to know that the Ninth Circuit currently makes audio playback of all oral arguments available through its website the day after the hearing, and frequently provides a live audio feed of oral arguments in certain cases. Further, and this may not be generally known, all arguments are recorded on the court's unobtrusive internal videotaping system for the court's own records. I have personally had 44 requests to allow cameras in oral arguments in which I have been a panel member, of which nearly 80% have been granted. In other words, I have personally participated in 35 appellate oral arguments which were videotaped or televised live, which experience is the basis of my testimony today. These requests range from high-profile attention grabbers to the comparatively banal. Among the more controversial three-judge cases were Brown versus Woodland School District, which considered whether certain Sacramento area classroom activities required children to practice witchcraft in violation of the First Amendment. Understandably, cases involving elections and the right to vote have generated substantial public interest and press coverage. For example, I sat as a member of a limited and bank panel of 11 judges in a very high-profile live video coverage of a case evaluating whether the California recall election of Gray Davis, the governor, should be enjoined as a violation of the 14th Amendment because of the use of punch card balloting machines. Of course, not every request to bring media into our courtrooms has been allowed. Panels, perhaps motivated by concern for the parties, have occasionally shunned cameras. For example, in Compassion in Dying versus Washington, the court grappled with whether a state statute criminalizing the promotion of suicide violated the 14th Amendment. Some judges will vote to deny video access unless assured that the media will broadcast the tape on a gavel-to-gavel basis. Indeed, just last weekend, C-SPAN aired the entire oral argument in Planned Parenthood versus Gonzalez, a partial birth abortion case that was argued several weeks before. Finally, Mr. Chairman, I appear before you today both in my individual capacity, supportive of cameras in appellate courtrooms, and on behalf of the Judicial Conference of the United States, which opposes cameras in trial courtrooms. Trial courts and appellate courts differ in important respects, primarily with respect to the presence of victims, witnesses, juries, and of course the parties themselves. For this reason, I have serious concerns regarding the placement of cameras in trial courts and suggest that questions about cameras in trial courts be directed to my district court colleague from Pennsylvania, Judge Jan Du Bois. And I thank you again, Mr. Chairman. I will be happy to take any questions that you or the committee members may have with respect to the use of cameras in the circuit appellate setting. Thank you.
Thank you very much, Judge O'Scanlan. Our next witness is United States District Judge Jan Du Bois from the Eastern District of Pennsylvania. Has served there since 1988, and prior to that time had a very extensive trial practice in Philadelphia with the law firm of White and Williams. He had clerk for Circuit Judge Harry Kolodner, received his bachelor's degree from the University of Pennsylvania in 1952 and his law degree from Yale in 1957, and in the interest of full disclosure, has been a friend of mine for 50 years, was at Penn with him. I did not make Sphinx, but Buddy Du Bois did, and distinguished record at the Yale Law School, and has been really an outstanding federal judge, handled major cases involving the prison system, and has no peer when it comes to hours in the courtroom, frequently running up the GSA bills on Saturday afternoons for air conditioning in the summer and heating in the winter, and he's well worth it and beyond. Welcome, Judge Du Bois. The last time you were here was for your confirmation hearing, and we have some tougher questions for you today. Please proceed.
Mr. Chairman, members of the committee, Mr. Chairman, members of the committee, my name is Jan Du Bois. I'm presently a judge on the United States District Court for the Eastern District of Pennsylvania.
Now it's on.
Yeah. Thank you, colleague. That's in return for punting the district court problems to me. I've served on the district court for 17 years. I'm appearing before you today in my personal capacity, and I appreciate the invitation to testify and hope my testimony will be useful to you. As you requested, my statement will cover the pilot program providing for electronic media coverage of civil proceedings in selected federal trial and appellate courts, 2 courts of appeals, the 2nd Circuit and the 9th Circuit, and 6 district courts, including my district. The pilot program authorized coverage only of civil proceedings. Guidelines were adopted by the Judicial Conference, and I have appended a copy to my written testimony. The guidelines set forth the procedures to be followed for using cameras in the courtroom. Significantly, they also prohibited photographing of jurors, and they provided that the presiding judge had discretion to refuse, terminate, or limit coverage. To give you some idea of the scope of the program, from July 1st, 1991 through June 30th, 1993, there were 257 applications for media coverage in all of the pilot courts. Of these, about 72% of the applications were approved. And of this total, 257 cases in which applications were made, about 30% were submitted in the Eastern District of Pennsylvania. The Eastern District of Pennsylvania conducted a study at the completion of the pilot program on December 31st, 1994. More cases had been the subject of applications, and the percentages remained about the same. Significantly, the breakdown of the cases in which applications were filed in the Eastern District disclosed that about 49% of them involved civil rights. Next in terms of percentage of requests were tort cases, 21%. The Federal Judicial Center evaluated the program, and I have a copy of their report. It's entitled Electronic Media Coverage of Federal Civil Proceedings in this program. It was published in 1994, and I understand it's on the Federal Judicial Center website. That report included ratings of effects of cameras in the courtroom by district judges who participated in the program, and I have appended a copy of that part of the report to my written testimony. The ratings by the judges who participated in the program were both favorable and unfavorable. For me, the most disturbing ratings are these. 64% of the participating judges reported that, at least to some extent, cameras made witnesses more nervous. 46% of the judges believe that, at least to some extent, cameras made witnesses less willing to come to court. 41% of the participating judges found that, at least to some extent, cameras distracted witnesses. And 56% of the participating judges found that, at least to some extent, cameras violated witnesses' privacy. In my experience, I had, I believe, a total of 4 applications for cameras in the courtroom. I granted 3, denied 1. Strangely, the media, I think it was Court TV, covered what I consider to be the least dramatic case, a product liability case, and rejected cameras in cases involving the prison class action to which the chairman referred. In deciding whether to allow cameras, I conducted a conference. The most commonly advanced objections offered by the attorneys were the adverse effect on the parties and the adverse effect on witnesses. In some cases, plaintiffs were concerned about disclosing matters of an extremely private nature, and Senator Sessions has already mentioned that. And in at least one case, a defense attorney said the threat of a televised trial would cause the defendant to consider settlement regardless of the merits of the case. As far as the adverse effect on witnesses, counsel were concerned that cameras would make them less willing to appear, and in general, the attorney's objections tracked the comments of the judges who participated in the program. I will say this about cameras in the courtroom. My personal view is that the disadvantages far outweigh the advantages. I say that mindful of the fact that our courtrooms have to be open, and indeed I think they are open. My concern about cameras in the courtroom stems from the fact that I think the cameras do more than just report proceedings. They affect the substance of the proceedings, and I say that based on my experience as a trial judge, my experience for 30 years as a trial attorney. I think that the impact or the potential impact of cameras on jurors, on witnesses, and on parties augurs for not allowing cameras in the district court. The paramount responsibility of a district judge is to uphold the Constitution, which guarantees citizens the right to a fair and impartial trial. In my opinion, cameras in the district court could seriously jeopardize that right because of their impact on parties, witnesses, and jurors.
Thank you very much, Judge Du Bois. Judge Scanlon, you testified that you have been a party to 35 appellate proceedings, and you've come to the conclusion that you think cameras in the courtroom, that it's desirable to have cameras in the courtroom, correct?
At the Circuit Court of Appeals level, yes. I think our experience now over 13 years, and it's continued since '91 all the way, and it's still on, has indicated that it seems to work well, and the vast majority of us feel that it's perfectly acceptable.
Any material impact on the lawyers who are presenting the cases or on the judges who are presiding in terms of responses for grandstanding or
well, you always wonder here and there.
Let me finish the question, Judge.
I'm sorry.
Let me finish the question.
I misunderstood.
Or in any way altering their regular conduct?
Well, you always wonder here and there of perhaps some aberrational moments, but by and large, I have never been offended by anything that the lawyers or my colleagues have said in a televised oral argument.
You
in my
maintained
court.
your same judicial demeanor, notwithstanding the presence of the cameras.
Well, we certainly,
it's a leading question.
We certainly try to, and hopefully we do.
Mm-hmm. Judge Du Bois, how many cases were televised in your courtroom?
In my courtroom, only one. I approved 3 applications, only one case, a product liability case, which did not involve personal injuries. It involved the recall of a line of bottled water.
What was the impact of cameras in the courtroom, if any, on you?
The answer to that question is none on me, and in that case, because of the rather bland nature of the case, the impact was positive. There was no negative impact at all. The parties did not object. The witnesses did not object. Cameras did not focus on the jurors, but I asked the jurors after they were impaneled whether they had any objection to having television cameras there, and they replied no. I should add...
So why with your sole experience with the cameras in your courtroom being positive, do you come to a different conclusion as a generalization?
I thought that, first of all, that case was a case that was tried on the first day of the program, July 1st, 1991. As my experience with the program and with attorneys who objected to cameras in the courtroom expanded, I concluded that there was an effect on some witnesses, on some jurors, and on some parties.
But not as a result of having cameras in the courtroom.
Well, I think the effect of cameras in the courtroom is a telling effect. Let me give you an example. The Federal Judicial Center reported that a large percentage of the judges concluded that there was an impact on witnesses, that witnesses became more nervous. Jurors are told to watch the way a witness responds to a question. If a witness is nervous because of cameras in the courtroom, a juror might very well misinterpret that to mean the juror is nervous because the juror is not telling the truth. That is a dynamic that I never want to see happen in a courtroom in which I'm presiding.
It didn't happen in the case that you presided where the cameras were present.
It was a rather bland case involving the recall of bottled water.
Well, how about cameras for bland cases?
I don't think the media would go for that, Senator.
Well, we'll give them the choice. Don't bar them if it's something they might choose to do.
Senator, may I say this, and I'm mindful the lights are going on, and I'm mindful of your experience in the Supreme Court in the Navy Yard argument, and I was afraid that today would be payback time for me, and that I'd be cut off in mid-word. But it seems to me
Time's
that
not up. Give us a chance. Chief Justice Rehnquist, as you know, is looking for an occasion to cut off a lawyer in the middle of the word if.
Well, I thought you might try to do that to me today. Thank you for not doing that, sir. I'm concerned that any compromise of an individual's right to a fair trial, any intrusion on that right, is not warranted because I think we have open courtrooms now, and the question is, do we need courtrooms to be more open? And I think if you can answer that question by saying there would be no trampling of individual rights in trials, that's fine. But I don't think we can say that based on the information that's presently available. And I wouldn't want to sacrifice the right to a fair trial in both civil and criminal cases to make courtrooms more open. And saying that, I want to add that I certainly favor open courtrooms, but believe our courtrooms are open now.
Well, my time expired in the middle of your answer, so I'm going to yield to Senator Sessions. But no, I'm going to stick to the time. But I'll maintain our committee record on that. But I will comment that we're all devoted to a fair trial, and we're not going to do anything that would impede on that. And I think the legislation which Senator Grassley testified about leaves it open to eliminate the cameras where the judge feels there'd be an impingement or where people object. Senator Sessions, participants and parties to the trial object.
Thank you. Judge Du Bois, the American ideal of justice is to create a climate for the very fairest outcome in every case that comes in a court of law in this country. Wouldn't you agree with that?
I certainly would.
We even give you two judges a lifetime appointment. We can't even cut your pay because we want an independent judge to preside over the trial who will take steps to make sure that trial is conducted in a way that guarantees that extraneous emotional forces don't come together in a way that might adversely impacted a fair decision-making process. Wouldn't you agree with that?
I would, sir.
And in your opinion, based on your years on the bench, you've concluded that cameras in the courtroom could be an adverse factor in guaranteeing as fair an outcome as we can possibly achieve.
That is correct, sir.
And now looking at the polling data that they did in New York to review their television coverage, it says they polled, and I think it's pretty startling, really. 43% of citizens would be less willing to serve on a jury if there were cameras. 54% would be less willing to testify as a witness to a crime if cameras were present. I think that's even more troubling. In a New York survey of voters conducted by Bill Bowers of Northwestern University found that 4 out of 10 potential victims would be less willing to testify in a criminal case if cameras were present. The Federal Judicial Conference study found that 64% of participating judges in the pilot program reported, at least to some extent, as you noted, cameras make witnesses more nervous. Do you agree? Do those polling data numbers confirm are consistent with your experience as a judge and your own observations?
I agree with the conclusions. My experience isn't broad enough to reflect specific percentages, but I believe every one of the factors that you mentioned from the New York study and the Judicial Center study are factors that weigh against a fair trial and should not be compromised to make our courtrooms more open.
Well, we just got to be careful. This is not, trials are critically important crucibles to ascertain truth. They're not for entertainment. They're there to help decide correctly complex, often emotional disputes between defendants and victims and prosecutors and between civil litigants and that sort of thing. With regard to one of the, well, I won't pursue that, and let me ask Judge O'Scanlan. Now, if you do a coverage of the appellate courts, is it, does the coverage cover the whole hearing, and then is it able, when it's put on the 6 o'clock news, do they just excerpt some small part of it? And does that give you concern that perhaps a incorrect perception might be conveyed to the public?
Senator, there's been a variety of experiences. Some of the cases in which I participated were video only with no audio, and snippets from that were used in the public broadcasting special program about the Ninth Circuit. In other situations, as I indicated, some of my colleagues will vote not to grant permission unless there is a commitment by C-SPAN or whatever the particular media entity is, that they would run it on a gavel-to-gavel basis. So it would be the full 20 minutes in a 10-minute argument or the full 40, that kind of thing. That's why I thought it was quite telling and quite impressive.
But let me just suggest, if it a local TV station that may have an interest in it, they would not be obligated to show the whole argument at 6 o'clock. They could simply show one snippet from it. Is that correct?
Is true, and that specifically happened in a case which was argued in San Francisco having to do with a cross on public property. There was a lot of local interest in it, and as a matter of fact, the local Bay Area television stations did indeed show it on a snippet basis.
Mr. Chairman, my time is out.
Thank you very much, Senator Sessions. And thank you very much, Judge Scanlon and Judge Du Bois. There are many, many more questions we could ask. We have your written statements. We have a very long third panel. So we're going to thank you, and we may be following up with some additional questions for the record.
It'll be our pleasure. Thank you very much, Mr. Chairman.
Thank you, Mr. Chairman.
We now call panel 3, Ms. Barbara Berkman, Mr. Peter Irons, Mr. Seth Berlin, Mr. Brian Lamb, Mr. Henry Schiff, and Ms. Barbara Cochran. Our first witness on this panel, too, is Ms. Barbara Berkman, who's testifying in her capacity as president of the National Association of Criminal Defense Lawyers. She's been a professor of law at the University of New Mexico School of Law. She worked as a staff attorney for the public defender here in Washington, was associate counsel for President Carter, bachelor's degree from Bradley, and a law degree from Stanford. Thank you for joining us, Ms. Berkman, and the floor is yours for 5 minutes.
Is this on? Okay. Mr. Chairman and distinguished members of the committee, as president of the 13,000-member National Association of Criminal Defense Lawyers, NACDL, I am honored to be here today to share the association's views regarding the important issue of cameras in federal courtrooms. While current rules do not permit cameras in federal district courts, NACDL's members have experience with televised proceedings in their state courts. And in discussing this issue recently with our board of directors, it was apparent that there is no consensus within the defense community regarding the overall desirability of cameras in courtrooms in criminal cases. The position of our association reflects that diversity of experience and opinion. The Supreme Court has held that there is no constitutional right of access for cameras in the courtroom. As a result, in criminal cases, the purported value of televised court proceedings must be weighed against the accused's constitutional rights to due process and a fair trial. The NACDL believes that S-829 does not strike the right balance. We would like to see the bill amended so as to authorize cameras in district court criminal proceedings and interlocutory appeals only with the express consent of the parties. In all other criminal matters coming before the United States Courts of Appeals and the Supreme Court, NACDL favors access for cameras. And there are many arguments on both sides. To the extent that cameras in the courtroom promote greater public understanding of the judicial process and the constitutional protections that apply to that process, we generally support their expanded use. Not unrelated is the notion that televised trials may encourage greater preparation and a higher standard of professionalism. But on the alternative, the arguments against cameras, there are many that concern us a great deal. First are pressures on jurors. The decision to televise a trial signals to the jury that their verdict is likely to be scrutinized by the viewing public, and defendants are less likely to receive a fair trial when jurors feel the need to reconcile their verdict with strong public sentiments in favor of a particular result. As a member of Terry Nichols' defense team in the state capital prosecution arising from the Oklahoma City bombing, we were extremely concerned about the possibility of strong community pressures being brought to bear on Oklahoma jurors if the court permitted cameras in the courtroom. We objected to the presence of such cameras under Oklahoma's rule permitting the defendant to object to cameras, and ultimately they were excluded. While it is impossible to measure the precise impact cameras may have had on that trial, the fact that some of the jurors have refused to speak to the media and others did so over a year after the verdict reinforced my belief that excluding cameras reduced at least some of the community pressure on the jury in the small community of McAllister, Oklahoma. And finally, past television coverage may make it more difficult to select an impartial jury in case there's ever a retrial. We also share the concern about pressure on witnesses, that it will discourage witnesses from testifying, that it may affect the ability of them to testify in a way that doesn't distort what they have to say, and that they will, as a result, affect hope. The concern we have is it will affect the jury's evaluation of their credibility. We also have concern about pressure on the defendant from cameras. They can affect the accused's demeanor and willingness to testify. And more fundamentally, the prospect of extended media coverage may discourage the accused from exercising their right to trial in the first place, and is a particular concern in cases involving humiliating accusations or corporate defendants unwilling to expose themselves to negative publicity. And it is also of particular concern in capital cases, where evidence of childhood sexual and physical abuse is frequently offered in mitigation. The prospect that such evidence may be broadcast across the country may cause a defendant to hide such information, even though it could save his life. Finally, even when the accused is acquitted, the stain on their reputation is not easily erased, and camera coverage may exacerbate this unwarranted punishment. Given these concerns, the sponsors of S. 829 have wisely avoided a rule authorizing unrestricted camera access, but rather than placing the ultimate decision in the hands of the presiding judge, we think the consent of the parties, the accused acting with the advice of counsel, and the government should be required before cameras are permitted to televise criminal trials or interlocutory appeals. The positive or negative effects of cameras depends on the facts and circumstances of each case. The parties who are familiar with the witnesses who will testify, the evidence that will be offered, and other facts that might indicate the potential for prejudice are in the best position to determine the appropriateness of cameras. Moreover, permitting the parties to withhold their consent avoids the time-consuming distraction of litigation regarding the judge's decision to permit or forbid that coverage. While we support efforts to ensure more sunshine on our democratic institutions, that goal should not be allowed to eclipse the fundamental purpose of a criminal trial, which is not education or entertainment, but justice.
Thank you very much, Ms. Bergman. Our next witness is Professor Peter Irons, Professor Emeritus of Political Science and Director of the Earl Warren Bill of Rights Project at the University of California in San Diego. Professor Irons has authored 6 books on the Supreme Court, served 2 terms on the National Board of the ACLU, an undergraduate degree from Antioch, PhD in political science from Boston University, and a law degree from Harvard. Thank you very much for coming in today, Professor Irons, and the floor is yours.
Senator Specter and Senator Sessions, I'm very glad to be here this morning. I'm going to limit my comments, and my statement is part of the record, if I might.
Your full statement will be made a part of the
Yes.
record, as are all the statements?
Right. I'd like to limit my comments to television coverage of the Supreme Court. And I base that on my experience with providing to the public access to the audio arguments, the audio tape arguments before the Supreme Court. And let me just give a little history behind that. Back in 1955, Chief Justice Earl Warren initiated the audio taping of Supreme Court oral arguments. I think he did so because he recognized the past term, the historic importance of arguments in Brown versus Board of Education, both the first and the second cases. And he felt that, that keeping those arguments on tape and making them accessible to the public would serve not only historic but a civic benefit, particularly for students. Now, until 1986, there was no restriction on access to those tapes. But in 1986, when Fred Graham of CBS News obtained a copy of the Pentagon Papers oral argument and played excerpts of it on television and radio, Chief Justice Berger imposed restrictions on access to those tapes, limiting it to what were termed private research and teaching. And I had decided in 1991, having heard some of these tapes when I was in law school, that it would be a good educational project to make them available to the public, particularly for use in schools. And so I obtained copies of 23 historical oral arguments, including Roe versus Wade, Miranda versus Arizona, the Watergate tapes case, United States versus Nixon, the Pentagon Papers case. And simply to illustrate, with the court's indulgence, I'd like to just push a button right here and for less than a minute bring you into the Supreme Court chamber for part of the argument by Thurgood Marshall, then Chief Counsel for the NAACP Legal Defense and Education Fund, in the historic case of Cooper versus Aaron, and I hope this will be audible.
I think we have to think about these children and their parents, these Negro children that went through this every day, and their parents that stayed at home wondering what was happening to their children, listening to the radio about the bomb threats and all of that business. I don't see how anybody under the sun could say that after those children and those families went through that for a year, to tell them all you have done is gone. You fought for what you considered to be democracy and you lost. And you go back to the segregated school from which you came. I just don't believe it. And I don't believe you can balance those rights.
Now, I played that, Mr. Chairman, to...
Mr. Irons, I don't think we all heard that.
Well,
I'll give you a little extra time. Summarize what was just played on the tape.
all right. It was an argument by Thurgood Marshall that about the experiences of the African-American children in Little Rock when they were being escorted into the schools through mobs, and how...
and what case was this in?
This was in Cooper versus Aaron in 1958. Now, my point here is very simple, that these tapes have been played in thousands and thousands of schoolrooms, and this is and I'd be glad to enter this into the record as well, a copy of that set of those tapes. And my own experience and the experience of hearing from literally hundreds of teachers and students who have heard these tapes is that they would very much appreciate the chance not only to hear these arguments, which very few of them have been able to witness in person, but also to see the arguments in the Supreme Court. And there's nothing, I think, more educational than that opportunity, making it available to the public and particularly to students to do that. This past Monday, I was talking to a class in judicial process at Missouri State University in Springfield. And I asked the class, and they had heard excerpts of these tapes, about 50 students, and I said, how many of you would really appreciate the opportunity to be able to witness these arguments in person, on video, to see the lawyers argue the cases and the judges ask questions? And there was a unanimous show of hands in support of that project. So I think in conclusion, Mr. Chairman, and Senator Leahy and Senator Sessions, that there would be a great public benefit. And I think that I also have available, I don't want to go over, a statement that I received yesterday by email from Chief Judge Mary Schroeder of the Ninth Circuit, on which Judge O'Scanlan sits, I think backing up his testimony, but also saying that, in my opinion, the Supreme Court and the public would benefit from at least experimenting with televised oral arguments in cases that, like the California case, are of intense public interest and presented by counsel of the highest ability. And I'd like to submit that statement as well.
It will be made a part of the record. Thank you very much, Professor Irons. We now turn to Mr. Seth Berlin, partner in the law firm of Levin, Sullivan, Koch, and Schultz. Has handled a variety of First Amendment defamation, privacy, and reporters' privilege cases, been nominated to the governing committee of the American Bar Association's Forum on Communications Law, has a magna cum laude degree from Brown University, bachelor's and cum laude graduate of the Harvard Law School. The floor is yours, Mr. Berlin.
Thank you, Mr. Chairman, members of the committee. I really appreciate the opportunity to testify today. At a fundamental level, ours is a government in which the people are sovereign and therefore possess the right to observe our government in operation. As the Supreme Court has explained, and as Senator Grassley alluded to in his testimony this morning, people in an open society do not demand infallibility from their institutions, but it is difficult for them to accept what they are prohibited from observing. Simply put, our democracy works better when people understand how their government institutions operate, and our government institutions work better when their operations are understood and scrutinized by the people. We have a constitutionally required right of access to court proceedings, and it cannot be seriously disputed that camera coverage will materially further most people's exercise of that right. The simple truth, as the Florida Supreme Court put it in authorizing cameras into that state's courts back in 1979, is that newsworthy trials are newsworthy trials, and they will be extensively covered by the media, both within and without the courtroom, whether cameras are permitted or not. It makes a lot more sense to provide the public with a picture of the actual in-court proceedings rather than having the public get its information about trials solely from secondhand summaries or worse, potentially prejudicial and inflammatory characterizations by interested third parties. Next, I'd like to point out that there is generally no constitutional bar to camera coverage. Following the Supreme Court's decision in Chandler versus Florida, courts confronting this issue routinely have concluded that television coverage does not interfere with the due process rights of a criminal defendant or of other parties or participants in a court proceeding. I'd also like to talk about the benefit of at least affording judges discretion in this area. A number of courts that otherwise would have found camera coverage warranted have felt constrained by either Federal Rule of Criminal Procedure 53 or by the Judicial Conference guidelines that prohibit camera coverage in trial courts. For example, in General Westmoreland's landmark libel trial against CBS, the parties consented to CNN's televising the proceedings. Then trial Judge Laval also made extensive findings that favored camera coverage. He nonetheless denied CNN's petition based on his conclusion that the rules of the Judicial Conference and of his own court left him no choice, a determination that was then upheld by the Second Circuit. And earlier this fall, a federal district court in Pennsylvania reached a similar conclusion relying on the Judicial Conference guidelines. The court denied a request by Court TV to televise the trial over the Dover, Pennsylvania School Board policy of suggesting the study of intelligent design, along with the study of evolution, despite the profound national interest on the subject, the consent of all of the parties, and the fact that the trial involved none of the usual potential objections that people raise in authorizing camera coverage. Legislation granting judges at least discretion to authorize camera coverage in appropriate circumstances may well have yielded a different result in these important matters and many other important controversies of the future. Finally, I want to talk briefly about the experience of those courts that have authorized camera coverage. Both the Federal Judicial Center study of a federal court pilot program and similar studies of experimental programs in a large number of states have confirmed that camera coverage does not interfere with the fair and orderly administration of justice. Moreover, the federal courts are increasingly using cameras for many purposes other than broadcasting court proceedings to the public. Judge O'Scanlan talked about the Ninth Circuit's internal videotaping system. The trial court in the Moussaoui prosecution authorized an audio-visual feed to a nearby overflow courtroom. And in response to the change of venue in the Oklahoma City bombing trial, Congress authorized closed-circuit televising of trials to crime victims where the trial is moved more than 350 miles and out of state. And lastly, there is the overwhelmingly positive record of camera coverage in the state courts. All 50 states allow at least some camera coverage of judicial proceedings. The best evidence that these rules work is that states have continued to operate under them in many cases for decades. California continued its practice of televising state court proceedings even after the O.J. Simpson trial left some to question that policy. And just last week, the Florida Supreme Court unanimously rejected efforts to limit its rules allowing camera coverage of court proceedings throughout that state's court system. To sum up, permitting federal court proceedings to be televised will dramatically enhance the public's exercise of its right of access to judicial proceedings. Congressional action will open the doors of the nation's federal court system to millions of Americans who are otherwise unable, as a practical matter, to view these proceedings.
Thank you very much, Mr. Berlin. Our next witness is the distinguished Chief Executive Officer of C-SPAN. Has been since C-SPAN was founded in 1979, has had a regular on-air presence with his book notes up until last year, and continues to have an on-air presence, as I can personally testify to, having been interviewed by Mr. Lamb as recently as August of this year. Prior to being a co-founder of C-SPAN, he worked as a freelance reporter for UPI Audio, a Senate press secretary, and a White House telecommunications policy staffer. In 1974, Mr. Lamb began publishing a bi-weekly newsletter called the Media Report and was Washington Bureau Chief for Cablevision magazine. A graduate of Purdue University, he majored in speech, where he received his bachelor's degree. And just a little anticipatory on the testimony. His C-SPAN covers Senate hearings with regularity, and I, for one, hear an enormous amount of comment about them. And people talk about C-SPAN with attentiveness only parallel to professional sports as to what this individual has observed. The next few minutes are yours, Mr. Lamb.
I just wonder, Mr. Chairman, before it starts, I know I know how much people watch this and actually watch Mr. Lamb, because I was walking through an airport once and somebody came up and said, "Mr. Lamb, how long have you been wearing glasses?" I said, no, he's a lot younger and he doesn't have to wear glasses.
But Senator Leahy, they do the same thing to me. Often in airports, Senator Leahy, can I have your autograph? And I have to disappoint them and tell them I'm not you. I have gotten that, by the way, Senator McCain and Senator Glenn, and I can go down the list of the number of people that I'm thought to be. I was in a classroom a couple of weeks ago, some 16-year-olds, juniors, talking about C-SPAN and what we do in government and civics. And one of the students put her hand up and asked me, and I don't remember why, it's an odd question. She says, where do they put the jury in the Supreme Court room? And it struck me as being, as Professor Irons is talking about, the educational value of all this being one of the more important reasons why we're even doing this. We have a commitment to make here this morning, and we've done it before, and that is basically if the Supreme Court will ever allow its oral arguments on television, we will carry all of them from start to finish. We'll find a place to put them all. As Judge O'Scanlan was talking about, members of the Ninth Circuit often want gavel to gavel. I'm personally not in favor of enforcing gavel to gavel. I think the news media play an enormously important role in interpreting, and I often find it fascinating because you can't really find out what the Supreme Court members think about television. They don't meet the public very often, and they often do, as the Chief Justice say, they have an open mind, and you never can really find out if they've ever voted on it or not. But I often thought it was odd because they would allow a member of the print press to come in and sit in the press area, a television reporter to sit in the press area, walk outside, stand in front of a camera, and interpret everything that went on in the courtroom. But giving us a chance to see how it really happened seems to be something that they can't agree to. We're interested in finding a place to carry every argument. There are only 80. And if you look at the statistics about the Supreme Court, there are only 50 seats in the court. There are 300 altogether, but only 50 where just an ordinary citizen who comes to this town who wants to watch an entire oral argument can sit and watch. So you have to get in line and you have to take your chances. There are 12 seats set aside for people to sit for 3 minutes, and that hardly does much for you other than being able to see what the court looks like. The rest of the seats are determined by either who's before the court in an oral argument or where the justices want to fill those seats with people that they know. So this is just like it was with the Senate in 1986 and the House in 1979, an extension of the gallery, an opportunity to see something that is usually an hour in length, and that particular event isn't going to determine how they vote. They go behind closed doors for that, and that's fine with us. But we're glad to answer any questions, and you have our commitment that we will carry all these oral arguments if we're allowed to.
Well, thank you very much, Mr. Lamb. We'll have some questions for you in a few minutes as we hear from Mr. Schleif and Ms. Cochran. Mr. Henry Schleif is chairman and CEO of Court TV Networks. Before taking on that position, he was active in a number of key posts in the television industry, including Executive Vice President for Studios USA, Executive Producer for Viacom, Senior Vice President for Viacom, and had been Senior Vice President for HBO. Began his career as a law clerk to Federal Judge Gerfine of the Southern District of New York, has a bachelor's degree cum laude from Penn, and a doctorate in law from the University of Pennsylvania Law School, where he was an editor of the Law Review. Thank you for joining us, Mr. Schleif, and we look forward to your testimony.
Thank you very much, Chairman Specter, Ranking Member Leahy, and Senator Sessions. On behalf of our nation's only television network dedicated to providing a window on the American system of justice, I am delighted and honored to testify before your committee, which is considering legislation that would provide our American citizens, both litigants and viewers, with the benefits of televising the proceedings of our nation's federal courts. This committee in particular is well aware of the fact that our trials and courtroom functions are open to the public and therefore to the press. Indeed, our founding fathers themselves well understood the importance and need for this openness. It is not by accident that they built a system of justice on really four great pillars: an independent judiciary, the right to trial by jury, rights of due process for defendants, and a court system which would be open to the public, whereas Justice Oliver Wendell Holmes well said, quote, "Every citizen should be able to satisfy himself with his own eyes." I do believe that all citizens today, not just the print press or those very few who can fit into a courtroom, should be able to watch their judicial system in action, and therefore that the few lingering concerns about electronic coverage or why it should be denied the equal access accorded print coverage are increasingly specious in the 21st century. Indeed, there can be no reasonable argument with the fact that advances in technology, such as a smaller and unobtrusive camera, merely expand the experience of being in the courtroom to the greater community, thereby making public trials truly public, as was intended by the founders. Certainly our system of jurisprudence, and especially our constitutional history of providing public trials, is an essential element of our democracy. Not only of our democracy, but of freedom. And just as the United States today represents a beacon of freedom, we should also allow that light to shine on the example that our own courtrooms provide. Our system is not perfect, but it is one of which we can and should be proud, especially in our ongoing efforts to preserve justice and freedom around the world. The importance to our own citizens of allowing cameras in the courtroom is really threefold. One, it enhances public scrutiny of the judicial system, which helps assure the fairness of court proceedings, a concern of Senator Sessions and one of which we all share. This, in turn, serves to further promote public confidence in our third branch of government. And three, it does increase our citizens' knowledge about how this branch actually functions. Because television is the principal means through which most people get their news, it only follows that the same vehicle be employed as a tool to inform and to educate the electorate in this way. Justice Louis Brandeis said it far more succinctly. Sunshine is the best disinfectant. We agree, and we vigorously support the proposed legislation which would open courtrooms to cameras and indeed let the sun shine in. Certainly, camera coverage of government proceedings is nothing new in the United States. Both houses of Congress have already opened their chambers to television cameras. This legislation would then merely provide the third branch of our federal government to be given the opportunity to take a similar step. Of course, as in the proposed legislation, which Court TV has long supported, trial judges are also to be given the discretion in their courtrooms to determine whether to permit a camera in a particular trial, which is a most important and practical safeguard. Today, there is certainly growing consensus in the United States that having cameras serves the public interest. Some 43 states permit cameras in their trial courts. Since 1991, Court TV has covered more than 900 U.S. trials and legal proceedings, providing more than 30,000 hours of courtroom coverage. Moreover, in our 15 years of such coverage, no judgment has ever been overturned because a camera was in the courtroom. On the contrary, a myriad of studies over the past 2 decades tracking the impact of cameras has indicated that they do not disrupt or otherwise interfere with the proceedings. If anything, cameras can help keep newspaper coverage, or for that matter, sound bites, whether we read them in the papers or hear them on the local news, in context, and thus provide the least sensational and most unfiltered form of coverage. And for this proposition, I will merely cite Senator Schumer's eloquent analysis of the Amadou Diallo trial. Finally, I should note that some justices of the Supreme Court have over the years claimed that allowing cameras in their courtroom would cause them to lose some degree of their personal anonymity or perhaps even lessen the court's moral authority. However, I would submit to you that where no witnesses or other parties are involved, just lawyers arguing to other lawyers, albeit lawyers dressed in robes, about issues which may fundamentally affect our daily lives, be it affirmative action, personal choice, or the like, the potential loss of anonymity would seem to be a fair price to pay.
Mr. Schiff, could you summarize the balance of your testimony, please?
Yes, I would say only in conclusion that we do think that such testimony to be seen at the Supreme Court level would do nothing but actually further the dignity with which that court is properly held. I would say, finally, that we do think that the American public deserves truly to see the judicial system in action at all levels and to have federal courtrooms open to camera coverage.
Thank you very much, Mr. Schleif. Our next and final witness on this panel is Ms. Barbara Cochran, has been president of the Radio Television News Directors Association. She has a very distinguished career in 28 years, significantly in Washington, D.C., vice president and bureau chief for CBS News, executive producer of NBC's Meet the Press, vice president of news for National Public Radio, managing editor of the Washington Star, has a bachelor's degree from Swarthmore and a master's degree from the Columbia University Graduate School of Journalism. Thank you for joining us, Ms. Cochran, and we look forward to your testimony.
Thank you very much, Mr. Chairman. Oops. I should know better. Thank you very much, Mr. Chairman, Senator Leahy and Senator Sessions, for inviting me to appear today on behalf of the Radio Television News Directors Association and the 3,000 television and radio journalists who are its members. RTNDA supports the Sunshine in the Courtroom Act, and we welcome Chairman Specter's legislation to open the Supreme Court to television coverage. We believe both bills serve the important public policy goal of instilling trust in the federal judiciary by allowing Americans to witness for themselves what transpires within the court system. It is simply not right that Americans form their opinions about how our judicial system functions based on the latest episode of Judge Judy or CSI. Nor does it make sense that the nominees for the Supreme Court are widely seen in televised hearings conducted by this committee, only to disappear from public view the moment they are sworn in as justices. RTNDA's members are the people who have demonstrated that television and radio coverage works at the state and local level, and they can make it work on the federal level. The interests of our citizens are not fully served in this day and age by opening federal courtrooms to a limited number of observers. By using today's technology, citizens can see and hear for themselves what occurs inside the courtroom. Technological advances have minimized the potential for disruption to judicial proceedings. Cameras available today are small, unobtrusive, and designed to operate without additional light. And moreover, the electronic media can be required to pool their coverage, cutting down on the equipment and personnel in the courtroom. The presence of cameras in many state courtrooms is routine and well accepted. All 50 states, as we've heard already, now permit some manner of audiovisual coverage of court proceedings. RTNDA members have covered hundreds, if not thousands, of state proceedings across the country without incident and with complete respect for the integrity of the judicial process. To the best of our knowledge, there has not been a single case since 1981 where the presence of a courtroom camera has resulted in a verdict being overturned or where a camera was found to have any effect whatsoever on the ultimate result. State studies show that reporting on court proceedings, both by broadcast and newspaper outlets, is more accurate and comprehensive when cameras are present. Unfortunately, the ban on cameras in federal proceedings means the public sees what takes place on the courthouse steps, not what transpires where it matters most, inside the courtroom. In fact, because of the federal ban, American citizens have been deprived of the benefits of firsthand coverage of significant issues such as whether the government can take possession of a person's private property and transfer it to developers to encourage economic development, whether executing juveniles constitutes cruel and unusual punishment, and whether the term "under God" in the Pledge of Allegiance is unconstitutional. In contrast, just last month, people throughout the world were able to turn on their television sets to witness the opening of the trial of Saddam Hussein. Iraqi officials apparently understood how critically important it is to make this process public to the widest possible audience. During the 2000 presidential election dispute, RTNDA fought hard for televised coverage of the arguments before the Supreme Court, and we were gratified when Chief Justice Rehnquist made the historic decision to release audio tapes at the conclusion of the argument. And we were also very pleased to hear our new Chief Justice express to this committee his openness to cameras in the Supreme Court. The release of audio tapes by the Supreme Court has educated the public and caused no harm. What is needed now is consistent and complete audiovisual coverage. Federal courts have not, on their own motion, taken steps to permit electronic coverage of their proceedings. Therefore, RTNDA respectfully submits that the time has come for Congress to legislate. This proposed legislation has the potential to illuminate our federal courtrooms, demystify an often intimidating legal system, and provide an appropriate level of public scrutiny. It is time to provide unlimited seating to the workings of justice everywhere in the United States. Thank you, Mr. Chairman, and I ask that some supplementary material be submitted along with my written statement.
Thank you, Ms. Cochran. We'll be glad to have the supplemental
Thank you.
material and put it in the record. Professor Irons, we now go to the 5-minute rounds for members. Professor Irons, do you think it is an appropriate matter for the Congress to act legislatively to open up the Supreme Court to television coverage?
Yes, I do, Senator Specter.
Do you have any doubt as to the constitutionality of such action?
No. As you pointed out in your opening statement, Congress exercises considerable oversight, direction of the federal courts, the composition, the procedures, et cetera. I think this falls within their purview. But one thing I would like to note, since Ms. Cochran just mentioned the audio taping of the Bush versus Gore arguments, is the response of Chief Justice Rehnquist to that experience. He was talking with Fred Graham afterwards. They were at a party together, and Fred quoted him as saying, Rehnquist said he was very pleased with the reception that the playing of the court's audio tapes had gotten. He said he watched it on television, and he thought it worked well, the way they put up the pictures that identified the justices and the lawyers who were speaking. He thought that the coverage communicated to the public what was happening in an extremely important case, and he was pleased. And so my point is that the next step beyond that, since the pictures were put up, anonymity, of course, disappears the minute those pictures are up, would be best served.
I'm sorry to interrupt, Professor Irons, but we have a lot of ground to cover. Let me move to Mr. Lamb. Mr. Lamb, would C-SPAN be in a position to cover the full television of the Supreme Court? Some of the justices have raised objections about snippets here and there. But would there be anything to lead C-SPAN to do other than total coverage just as you do now for the Senate and the House of Representatives?
No, it would be exactly as we do like this hearing today. The whole hearing will be on C-SPAN. It'd be the same thing with every oral argument.
What information do you have as to the ratings for C-SPAN? How many people watch C-SPAN?
We don't take ratings. We do surveys from time to time to find out if there's anybody out there watching. And it's really interesting because we're the only network like it that we have no idea on a quarter-hour basis who's watching. We have been able to identify that out of a country of almost 300 million now, that about 10% of the society is interested on a daily basis in the kind of things that you're doing and what we're covering. They come to us all the time to see if there's something there of interest to them. There are another 3 in 10 people who are interested when things get a lot of national attention, and they'll come to us. Then there's 6 in 10 people that never watch. But it would make sense to you if you just look at the voting numbers that only about half the people vote in a presidential election. So I suspect that most people that don't vote won't watch what we do.
You now have C-SPAN 3 where you make selections as to what is going to be shown, and some very wise judgments from what I've seen. For example, you covered our hearing yesterday on Saudi Arabia.
Brilliant decision.
I have an instinct that C-SPAN 3 gets more viewing than 1 which has the House and 2 which has the Senate. Any comment?
Don't know. C-SPAN 3 is not in nearly as many homes as 1 and 2, and it's on the digital tier, the technical language, which means that people have to go after it, have to find it. But I think as time goes by, as the whole television world is going to change, that people will have the same access to C-SPAN 3 as they do to the other 2 networks.
Mm-hmm. I have a question for the other 4 panel members, which is a big one based upon the testimony of State Judge Du Bois, who was concerned about how television would impact at a trial, impact on the statistics which Senator Sessions cited about jurors being less willing to serve. And I thought Judge Du Bois made a very telling point about witnesses being nervous, being televised, and that might impact on jury evaluation. So that I'd like to ask the 4 of you, because my time is going to expire in just a few seconds, how you respond to the concerns which Judge Du Bois and Senator Sessions raised as to the ability to guarantee a fair trial if it is televised. Start with you, Ms. Bergman.
Yes, Senator Specter. I think our proposal is designed to address that, and that is that consent of both parties, both the defense counsel, and I address only criminal cases, and the government would be required before televising of the trial would be permitted. Because those are the people who know the case the best. They know the witnesses, they know the evidence, they know the issues that may arise. And by giving those parties the opportunity to give consent or to not give consent, they're in the best position to guarantee that the trials are fair. And they can take into account those concerns about jurors, the concerns about the witnesses, the concerns about the impact on the defendant as well.
Mr. Brilliant.
Thank you, Senator. I think that the experience of the state courts that have trial coverage with cameras, which is now a very broad experience, in some cases lasting decades, demonstrates that these concerns are not to be completely overlooked, but can be easily managed. The bill that is currently before the committee, which affords trial judges discretion to handle this, has built into it protections on this issue. And in particular, if a judge is exercising discretion, the judge, and I would submit with no disrespect to Ms. Bergman, that the judge is actually in the best position to balance all of the interests that are before them in a court, that sometimes parties have a particular interest that may or may not be actually consistent with what's the appropriate thing to do, and that overwhelming record really demonstrates that that this is possible to do without interfering with the fair and impartial administration of justice. When criminal defendants and other parties have challenged on appeal the presence of cameras, there is a very strong record of courts saying that they have not, in the manner that they've been used, interfered with the operation of the trial court. And based on that experience, I think those concerns may be a bit overstated.
Mr. Schleif?
Yeah, I agree. I think the most recent New York study actually spoke to that very point. I quote, "Witness intimidation is neither borne out by the record nor sufficiently strong to warrant barring cameras from the courtroom across the board." I think it is exactly the judge's discretion which has to be used, and I think which is appropriately provided for by this legislation.
Ms. Cochran?
Yes, I agree that the important thing about this bill is that it gives the discretion to the judge, who's in the best position to make the decision about whether cameras should be admitted or not. And I also would refer to the state experience with many states. Some have been allowing cameras into trials for as much as 20 years, and there have not been the problems that are feared.
Thank you. Professor Arms, my time has expired, so I don't have time to ask you a question now, but I interrupted you. Keep that thought in mind because I'm going to come back to you.
Okay.
Senator Leahy?
Thank you, Mr. Chairman. Thank you, Mr. Chairman. I just want to make absolutely sure I understand, Professor, what your answer to Senator Specter, because he's asked a question I was concerned about. You see no problem with the constitutionality?
No, I don't, Senator Leahy.
I don't either, but I just wanted to get that on the record. And Ms. Bergman, I'm correct in my that some in the defense bar are for the idea of the camera, some are opposed.
There's a diversity of opinion, Your Honor, depending upon what court we're talking about. Generally for appellate argument or Supreme Court argument, the defense bar, at least our board of directors, didn't have any major opposition to that at all. Our concern is with the impact on jurors, witnesses, defendants at the time of trial.
But that also requires some sense on the part of the trial judge not to allow it to turn into a circus. I mean, you can easily, a trial judge can easily, for example, protect the identity of jurors. I mean, you can easily set it up in such a way that jurors' faces will not be shown or any reaction of jurors during a trial. Is that not correct?
Your Honor, Senator Leahy, there are steps that can be taken to try to provide some safeguards to protect the identity of jurors, but that does not address the concerns about witnesses who will refuse to come forward, who will refuse to testify. It does not address the concern of the impact on witnesses when they testify and how it may affect their demeanor in the courtroom and how they present their testimony. And it doesn't deal with the issues of the very intimate, private types of information that if people think it's going to be televised nationally, they're not going to want to testify, or in some cases you'll have situations with a defendant who will say, I don't want that presented because I don't want that broadcast. And so it's going to have an impact that cannot be evaluated merely by protecting identities of jurors.
Now we could discuss it further, having defendant cases and having prosecuted cases. I still come down allowing the public to know. I might ask Mr. Lamb, as far as keeping down the intrusiveness, I just sort of, we're halfway through this hearing before I realized there is a robot camera here in front of me going back and forth. That's relatively easy to do, is it not? To cut down, from a technical point of view, cut down the intrusiveness of cameras, which doesn't go to Ms. Bergman's question, of course, of having yourself seen when you're testifying, but at least as far as the conducting the trial, you can lower the intrusiveness of cameras.
I think Henry Schleif would be better at, he's done a lot more courtrooms than we have, but when you're talking about the Supreme Court, they undoubtedly, if they ever get to television in the court, would want to operate their own system just like the Senate and the House does. And you can basically hide the cameras, make it very easy, and people who go before the court won't even know there are cameras in the room.
Justice Scalia recently noted on C-SPAN that he wasn't concerned about gavel-to-gavel coverage of oral arguments, but was concerned that cameras take these 15-second outtakes that can distort rather than inform the public. Isn't this really a question of whether the press acts in a responsible way? I mean, I remember during the Michael Jackson trial, we had every night, I was so glad to see that genocide in Darfur and others had obviously ended because the national press didn't bother to cover that anymore. They had this one molestation case out in California, but isn't that a question for the media and their own responsibility?
As I said earlier, the justices have a different view of the electronic press compared to the writing press, which I just don't understand how you can delineate between the two, but they do. Justice Scalia has a very unusual view of what television ought to do. He likes the idea of gavel to gavel, doesn't want the snippets, and even when he goes out to speak, he will often say, if there are television cameras in the room, I won't speak. Yeah. We had a little bit of openness earlier this year for about 3 sessions, but that's it's been a tough go, and we've had public comments about all this and have great disagreement with him. I just think you can't delineate between the two. It's the First Amendment applies to everybody.
As Ms. Cochran had stated earlier, you get this great view of justice during our hearings, and as we will of the latest nominee in January. But then the marble walls close in. Isn't it true, Ms. Cochran, there are examples, a lot of examples where coverage has worked very well. I'm thinking, for example, I was one of the ones that urged the Attorney General to make coverage available for the families in Oklahoma City trials, because the trial was inappropriately moved to change the venue, but the families who wanted to watch the trial weren't able to pick up and go too. But wouldn't that be an example of how justice, I mean, all sense of justice, the victims and everybody else, were served?
Yes, I mean, the easiest way to provide access to the widest number of people is through bringing a camera into court, and that's an excellent example. The families were able to see what was taking place in the courtroom, and it didn't appear to have any of the intimidating effects. Our members work with judges all the time on the ground rules for coverage. If they won't show jurors if there is a witness whose testimony needs to be taken in privacy. That's something that the judge can order, and so on. So all of these things can be worked out. But I think the important thing to remember is that the trials were designed by our founding fathers to be public, and so concerns about embarrassment and that kind of thing, these trials are public anyway, and the presence of a camera is not going to make a significant difference in that. I also, with your indulgence, I'd like to address the snippets issue, if I may. We prefer to call them sound bites or excerpts. The proceedings are going to be covered by the press anyway. Newspaper reporters are going to take selected quotes. Television reporting is going to use selected quotes. And if there are cameras present, then the quotes that are used will be the actual words as they were delivered by the people delivering them, rather than having it be a mediated secondhand account of what was said. So it really enhances the accuracy of the reporting rather than taking away from it.
Thank you, Mr. Chairman. I think these are valuable hearings. Thank the panel.
Thank you very much, Senator Leahy. Senator Sessions.
Ms. Bergman, I think you're alone in this group.
I feel alone, sir.
A good defense counsel is used to that sometimes. Under the legislation as you read it, do the parties, the Grassley bill, do the parties themselves have any ability to object?
My understanding is that it's a decision that the judge has the discretion to make, and I would assume the parties would have an opportunity to be heard on it, but ultimately would have no right to object to keep the cameras from actually coming in. And it raises another concern, Senator, which is that in that whole process, if the parties have grave concerns about the impact this is going to have, it's going to require hearings before the judge to present this evidence, to raise this issue, to potentially disclose defense theories that counsel would prefer not to be disclosing at that stage. It raises the possibility of increased litigation and taking, quite frankly, time away from the trial lawyers' preparation and work on the trial, rather than focusing on this peripheral issue. That was a concern we had in the state capital prosecution in Terry Nichols, and luckily we were able to have a professor from Kansas who came in to litigate that issue for us, because it ended up being a writ all the way up to the Oklahoma Supreme Court, and it took a lot of time and energy that could have been better spent in other ways.
And if a defendant, civil or criminal case, or even a plaintiff, is threatened, let's say, that we're going to call witness such and such, and that witness is going to say horrible things about you, do you think it makes if you go to trial and you challenge us and you force us to go to trial, do you think it's a quantitative difference that might be videotaped and then might be on the evening news as opposed to maybe being reported in the newspaper?
Absolutely. I think it makes a tremendous difference when it's broadcast with a camera in the courtroom, putting it on the evening news. It's qualitatively different in terms of the nature of the impact of that. And I think it impacts in several ways. One is the fear that a witness will be called to say certain things. The other, the aspect of, I don't want to put someone through testifying and being televised and having to talk about those things. And I've been involved in capital cases where there were defendants who did not want very painful information presented by relatives, friends, family members. And it was an extreme effort to get them to agree to do that. And then if they thought that it was going to be televised nationally, I know it would have made a tremendous difference.
And is it your experience, and has been mine as a prosecutor from quite a number of years and a defense attorney on occasion, that some of the key things you have to do is just spending time holding the witness's hands. They're just terrified.
Absolutely.
And if they're told they're going to be on television, maybe national television, do you think it adds to the terror and concern that they face?
Oh, it would just magnify it astronomically.
Now, you've said the parties have a right to object. Does that include the prosecutor?
Yes, sir.
That's good. Thank you, Mr. Chairman. I would just say this has been an excellent panel, raised some very important issues. I think there's a remnant, Mr. Lamb, out there that keeps up with America. I call them a patriotic remnant that know more what goes on here than we do. We've got this committee just down to you and me, Mr. Chairman, and here we are. We're sitting here, but some people are watching every word of this, maybe more than the Senate, and they are forming opinions with less stress and pressure on them than we have, and I think it's healthy. So I really do believe that. But as a person who's tried a lot of cases, I'm inclined to think the judges may be correct. Their overall perception that justice would not be enhanced in the trial court, but we'll continue to discuss it. Thank you.
Thank you very much, Senator Sessions. Professor Irons, you were in the midst of commenting actually beyond the scope of my question, which is why I wanted to move on before, but let's hear what you have to say.
Well, what I was trying to get across, Senator Specter, was simply that we have and have had for 50 years now access to the words that are spoken in the Supreme Court. And it's a very small, and I think pointed out very aptly, now because of technology, unobtrusive process to add faces to those words. and to give a sense, particularly, I remember last year when I was attending the Supreme Court oral arguments in the Pledge of Allegiance case, sitting right behind Dr. Newdow in the bar section of the court. I couldn't imagine a more educational experience than being able, particularly for students, but for the general public as well, to see those arguments. They were dramatic on both sides. And I don't think it would have detracted from the decorum of the court or any of its proceedings to be able to witness those kinds of arguments. And so I think that my own experience in talking with students at every level, from 4th grade all the way through high school, playing them excerpts of these arguments, trying to explain what was going on in the court, would be enhanced immeasurably. And I'm simply talking now about the appellate level of argument, but would be enhanced immeasurably by being able to see those proceedings as well as just listen to them.
You testified in your opening statement that it was Chief Justice Earl Warren who began the practice of recording the Supreme Court arguments?
That's correct.
Was there any contemporaneous statement made or any statement made later by Chief Justice Warren as to why he did that, what his thinking was?
Yes, as a matter of fact, Mr. Chairman, in the accession file at the National Archives, these arguments have been moved from the Archives building downtown out to the Suitland, Maryland. But in the accession file, and I'm probably the only person who went through that file after there was an effort by the Supreme Court to limit my access to the tapes, statement by Chief Justice Warren sent to the archives along with the first batch of the tapes, saying that he wanted them open to the public. It wasn't until 1986 that restrictions were put on access by Chief Justice Berger, and those restrictions remained in place for 7 years until these tapes were released, and the court decided, I think very wisely, particularly in view of the publicity that their effort to restrict them had produced, to lift the restrictions again. So now, as a matter of fact, you can go into the Supreme Court bookstore, really just down the block, and purchase CD-ROMs called the Supreme Court's Greatest Hits, which have the arguments in 62 cases, the full arguments. These, of course, are edited and narrated for classroom use, so it's hard to keep students' attention during an entire hour of argument. But I think my basic point really is that I can't see any detriment to the Supreme Court or to the U.S. Courts of Appeals in having the pictures added to the words that are already available to the public.
Do you think Chief Justice Warren would have been wise to have had audio recordings of the Warren Commission proceedings made available to the public?
I think so. As I said, Chief Justice Warren recognized, and of course he came from public office. He was very used to his words being recorded and reported in the press, and it didn't intimidate him at all. But I think what he recognized was that having presided over the second round of arguments in Brown versus Board of Education, and I searched high and low in the archives hoping that they would be there somewhere, but that is an experience that should be recorded and preserved for the public.
It was difficult to get Chief Justice Warren to agree to print the transcripts of the Warren deliberations covering 26 volumes and 17,000 pages. The staffers had to go to the congressional members who were used to printing large volumes of materials in the congressional record which weren't too salient or pithy, P-I-T-H-Y, and that was done. Mr. Schleif, what about ratings for Court TV? Mr. Lamb doesn't rate C-SPAN. I'm sure do you rate Court TV?
Yes, we do.
And how are your ratings?
They're good these days, yeah, sir. But in fairness, most of our ratings or our focus on our ratings come from the proverbial prime time in the evenings from 8 to 11. While we do have ratings during the day of our hearings and our coverage of proceedings, they are important to the overall brand, if you will, of the network. But it's not where we derive any principal portion of our revenues or anything else, but they are indispensably important to what Court TV, obviously given the name, stands for. And yes, it's a core audience that watches it. It's an audience that's very devoted, actually, to the process.
How many hours a day do you televise?
The entire day, pretty much 9, right through when most of the, certainly on the East Coast, courthouses close till 5 o'clock.
And how about overnight?
We'll repeat sometimes a portion depending upon what the case is, and some of it on the weekends. But overnight we go into something else which is called our more entertaining or seriously entertaining mode.
Mr. Lamb, you do interview Supreme Court justices from time to time. What has C-SPAN's experience been on that?
Well, the most interesting experience was Chief Justice Rehnquist, who over a period of about 15 years let us sit down with him 4 times. And it was always odd to me that he would be so open personally, and when he would go out to speak at his circuit or he'd give a speech, he'd allow our cameras in. He never refused that. But when it came to inside that courtroom, he just shut her down. I mean, several years ago, we would take our cameras into the press room, set up and do live programs in there. All of a sudden, one day, he sent the word down, no more. It's really hard to know what the thinking is inside that conference room when they make some of these decisions and they vote on them. A lot of justices, there's really only one justice out of the 9 that are there now that really has not been open, and that's Justice Souter, to anything. We've done lots of programs with these justices and kids, live, coming out of the East Conference Room in the Supreme Court. We've actually had on the air over the last, since we've been cataloging this since '87, 700 different events involving Supreme Court justices. So it really, the closer you get to that courtroom, the more they want to shut it down and don't want to open it up for some reason.
On those events, you have televised all members of the court except for Justice David Souter?
And Justice Scalia has been very uninterested in television cameras, the 2 of them, but all the rest of them, you can go into our files and find tape. We have it in our archives. All these, I mean, if you want to see what these justices look like and what they sound like, after, we've done all the hearings that you've been involved in, you can go to our archives and still find them to this day.
Will you say Justice Scalia has been uninterested in television?
Yes, he has. I mean, he opened 3 events this year, and that's the first time since he's been on the court that he has allowed our cameras in. If he sees a camera in the court, in his giving a speech, and he gives a lot of them, he'll just say, either take the camera out or I'm not going to speak. And we have not been able to...
Anybody ever choose alternative B?
Well, interestingly enough, let me just take a minute to tell you what happens, and it's a disappointment.
You can take your time. My colleagues have all gone.
The disappointment is this, that the venues where he speaks, often universities, often connected with law schools, frankly will cave. They'd rather have him there instead of upholding the principle of openness. One of the best examples of this was the City Club of Cleveland, who a couple of years ago gave him the Citadel of the Freedom of Speech Award. And Justice Scalia went to Cleveland to accept the award. And normally, we cover the City Club of Cleveland all the time. We were told we could not cover this time the Freedom of the Speech Award given to Justice Scalia. Once they've made up their mind in the court, it's hard to change it, and we have not been successful.
Well, perhaps he's modulating a bit. Perhaps he has a little different point of view. I think that we really need to get a public reaction to televising the Supreme Court of the United States. And my instinct is the public reaction is going to be very positive. The public does not know what has happened to government in the United States. the court has taken over and rules with very much an iron hand and very much an inexplicable hand. When we had the hearings for Chief Justice Roberts, it provided an opportunity to discuss in some detail what the court has been doing. And when we analyzed a case called United States versus Morrison, which involved the Supreme Court's declaring part of the act unconstitutional, protecting women against violence, we were able to publicize that the court, in a 5-4 decision, found as it did because they disagreed with the Congress's, quote, method of reasoning, close quote. Up until that decision, Commerce Clause questions had been decided on whether there was a rational basis for the congressional judgment based upon the numerous hearings which Congress holds. And the 4-person dissent said that there was a mountain of evidence, but Chief Justice Rehnquist disagreed with our method of reasoning, which I found and said at the hearings highly insulting. And then they upheld parts of the Americans for Disability Act on access with a paraplegic 5-4 and denied coverage for Americans for Disability on employment. And Justice Scalia denounced the standard as a flabby test, he called it, designed to have the court be the taskmaster of the Congress to say that we had done our homework. And they made the decision based upon a test called congruence and proportionality, which was invented in 1997 in a case called Burney on Religious Restoration Act. And Judge Alito is going to be asked, as Judge Roberts was, Chief Justice Roberts was, then Judge Roberts, to comment about that standard. But I think Americans would be flabbergasted to hear that the court devises some test on proportionality and congruence and expects the Congress of the United States to know what the standards are. And I think it would put some legitimate pressure on the court to come down with decisions, if not understood by C-SPAN's audience, at least understood by the Judiciary Committee. So we're gonna continue to push it, and it's a question of when, in my judgment, not a question of if, and the sooner the better. Senator Feingold could not be with us today. Without objection, his statement will be made a part of the record, and we thank you all very much for coming. That concludes our hearing.
Yeah. It always he's the taskmaster doing to keep everything as far as the timeline and everything going, and then at the end it just kind of gets right, does everyone.
Are you serious? Oh yeah. How you doing? Hey.
In a moment here on C-SPAN 2, a look at energy-saving technology and global climate change. And the Senate returns live at 9:45 a.m. Eastern to continue work on defense programs.